Good morning, everybody. Welcome to our launch. Could I call upon the Right Honourable the Lord Newberger of Abbotsbury, our President, to say a few words by way of introduction. David.
Welcome you all, both those who are physically coming remotely and me was thwarted because I haven't turned the microphone on. I'm sorry. I was saying to welcome all of you who are present here today in front of me, and those who are on screen and are hearing, I hope, us remotely, to the launch of the Global Toolbox Corporate Climate Litigation, which is a very significant event. The importance of climate change in our lives and the lives of our children and grandchildren is self-evident and much discussed. And many people are aware of things that need to be done. But as usual, there is a big gap between what people know or feel should be done and being prepared actually to do it. And exercises such as this and events such as this, I think, are vital to aim to end up with the possibility of actual change rather than talking about it. You will hear from the two chairs, Ivano and Nigel, about the remarkable work that has already been undertaken in preparation of this exercise and what's already been done in relation to the toolbox. The role of the British Institute of International and Comparative Law is particularly appropriate. It is a neutral body with many lawyers and others working for it across the world, with a reputation of doing important work, which actually has results, and it has many stakeholders, and its commitment to environmental protection and the environment generally has already been established by a number of documents it's produced and a number of seminars it's held. The particular importance of the corporate part of the world in climate change has perhaps been rather ignored until recently. There are apparently some 2,500 climate change litigation claims across the world. 3/4 of those approximately are against states or public bodies, but there are an increasing number brought against the corporates. And in a world where we are increasingly aware of the vital role, increasing role of companies as against governments, this is a particularly important area. So the combination of BICL, the climate change, and the role of the corporates meets together in this toolbox. And I'm very pleased at the number of people who've turned up, and if I may say so, the quality of the people who have registered for this event, both remotely and in person. And some in person coming from as far away as India and Japan, specifically for the purpose of this exercise. The corporate climate litigation toolbox, as you will hear, has already got a large number of people signed up across the world. And I think that after today, and hope that after today, it will have even more people. And I welcome this event, welcome you to it. And I hand over to the chairs today, the leaders, Ivano and Nigel. Thank you very much indeed.
Thank you, David, for introducing today's launch. All who have worked within BICL on the project are grateful for your leadership. I've been asked to say a few words about the genesis of the project. In February 2020, the International Bar Association launched its report and a model statute for proceedings challenging government failure to act on climate change. In the preface, the IBA Working Party said this, and I quote, "Addressing global climate change requires many solutions. Citizen climate litigation can provide a critically important means for people and vulnerable communities to ask courts to require governments to reduce greenhouse gas emissions and other measures to reduce climate-related impacts. Recent citizen climate litigation has led to judges in some countries requiring governments to assess and take action to address climate change. On the other hand, in many other countries, legal obstacles might prevent citizens even getting through the courthouse door or judges from adapting existing judicial procedures to remedy government climate inaction. I attended the launch of the model statute in London and was inspired by the content. However, both the report and the model statute addressed only litigation involving governments, public law actors. The obvious omission was litigation involving non-government bodies, commercial players, private actors. At about the same time, in January 2020, Ruth Keating and I, colleague in Chambers, were working on a piece for Bickel on the UK's experience of climate change litigation. There was a seminar and eventually a book, and there was the connection. In the autumn of 2021, Bickel decided to consider and tackle the IBA omission, not intending to produce its own model statute, but to produce a toolkit or toolbox, for want of a better word, based on an independent comparative analysis of climate change litigation involving commercial, non-governmental interests around the world. In light of the special subject matter, the main purpose or aim was to identify procedural mechanisms, causes of action, remedies, which might make such litigation speedier, more efficient, so that if there is merit in the claim, it could be and should be adjudicated on with the minimum delay, and steps taken by the courts and arbitrators to produce the necessary informed relief, decisions, judgments, awards that may assist in the reduction of greenhouse gas emissions and or compensate affected parties or making other appropriate orders. It took some time to get the necessary funding, with tireless efforts by Bickel's fundraisers, but we got there. A huge thank you to those who have made the project possible, and nearly 3 years later, we are here, launch day. I've been lucky enough to play a small part in the development of the toolbox, and I look forward with the keenest interest to see how it is received and refined over the next year or so. As I said, I'm a small part. The main overseeing and creative role has been taken by Ivano, who, unbeknown to me, was also at the IBA launch in 2000, to whom, with great relief, I now hand over.
Many thanks, Nigel. Yours have been a fundamental role since day one of this project. And even before that, you may not know, but Nigel, besides his successful practice as a barrister, King's Counsel is also a Bickel Honorary Senior Fellow and the chair of our project core group. So, ladies and gentlemen, esteemed colleagues, esteemed guests, and all the experts that are following us from every part of the world in this moment remotely. It is a great honor and pleasure to be at Bickel today to introduce, along with so many colleagues, friends, and great experts from different countries and from all the continents, what we all will be pivotal resources in our collective quest to tackle climate change. So, following what Nigel said, in September 2022, Bickel embarked on an ambitious journey to address the intricate web of climate litigation involving corporations with the project Global Perspective on Corporate Climate Legal Tactics. This project was not just a research endeavor, but it was a mission to craft a universal practical compendium for legal practitioners across the world and anyone interested in this fairly new field of litigation. So you find here the QR code also, if you want, embedded in this slide to access the project web page. Today, we present the fruit of this journey, the Global Toolbox on Corporate Climate Litigation, an evolutive, collaborative, and open access platform designed to equip NGOs, but also companies, government entities, local communities, and legal professionals with a diverse set of instruments tailored for corporate climate litigation. So you see here our analysis. This is the first time that we are showing to the public. So this is our work encompassing 17 countries from every continent, as I said, and is founded on 3 axes. So as you see, we have the causes of actions, and then you see we try to incorporate the most significant, but as we said, this is an evolutive project, so we will probably add some more in the next months. And there are the procedure and evidence, the second axe, and then the remedies, of course. So as you see here, in a way, this comprehensive framework is mirrored also in the toolbox structure, offering users legal models, authoritative references, and also strategic insights. You will see that most of the toolbox sections follow a similar structure with an overview. Then we have a graphic summary showing the 3 main points: established legal avenues related to a cause of action, or, for example, procedural issue, its related hurdles and challenges, and of course the potential legal avenues, because as we said, this is also a prospective kind of work. And these are developed, of course, in more detail through the analysis of case law in different countries, as you can see on the part on the right side of the slide. You will also find the main elements and essential definitions in relation to each topic, as well as their most relevant sources of law. And we finish every section with the country summaries. It is important to highlight here that this toolbox is not merely a platform, is a testament to global collaboration. Legal system, as you see, as you know, are varied, but our challenges at this point are shared. So let's see a little bit what the people that contributed to this work, because we have integrated insights, as I told you, from 17 national reports and expertise from a core group of internationally recognized experts, both from the Global South and North. And they are all part of this wider international expert group, the orange part of the slide, as you see, with more than, at this point, 200 experts worldwide, ensuring a rich tapestry of perspectives benefiting from the wisdom of the judiciary, legal practice, academia. Each one of them have contributed to our work during the different national and comparative workshops, during the public events that you probably participated in the last year, through discussion, consultation, and reviews of the different sections of the toolbox. So you see now some of them, probably some of them are already well known. There is, of course, as we said, from the Global South, we will hear from Qintian Pao. From China, we will hear from other expert groups like Jackie Peel from Melbourne. We have, of course, our chair, Nigel. We have Michael Gerard, that we're going to speak also later, and the director of the Sabin Center. As you see, it's really quite heterogeneous. This core group, they are the one that advise us in the different phases of our toolbox. And this is, in a way, the international expert group, which is represented by the different flags, the 17 countries. You are going to click on that if you want to see in details who has contributed country by country to these reports and to our work. And then, of course, our goals, which are hopefully clear: to map corporate crime litigation globally, to catalog pivotal cases, foster strategic thought, which might be helpful in litigation planning, and motivate corporate climate change through raise awareness of litigation risk. So in a way, I think that this is a little bit a very short introduction. And what we launched today, as you see, is not, as we said, not a static, but an evolutionary platform developing through the ongoing dialogue with our international expert group, which keeps growing every week, including new experts in many different fields. And this dialogue and expansion will continue through the 17 national conferences, 5 regional summits that you see on this slide, with the UK conference at the London School of Economics and Political Science starting today at 2. So if you want to go and participate there. And during these events, as we said, we will try and include all the relevant stakeholders in the discussion to test, to provide the feedback, and to improve the toolbox. In a way, it's really important to highlight that this toolbox is, would say, really at the beginning. We will need also your help. We need to keep discussing on this and to improve this toolbox. Looking forward, the toolbox will expand into a even more robust platform, including a rich collaborative repository of literature. You see already here, we have the 3 parts of the toolbox platform, the CCL platform that are the CCL resources, corporate crime litigation resources. The second one actually is there, but is a work in progress, is a user-friendly AI-powered database, which will be developed in the next months in collaboration with Climate Policy Radar. And the third one is where you will find the toolbox, is the comparative laboratory, where we keep and we try to deep our analysis related to corporate climate litigation. So this is this part. You see the CCL resources. You will see all the different parts. So this is already active since December. We presented during COP28, and is a literature repository established and still growing thanks to the international expert group members. And as you see, we will have references to books, journals, reports, webinars. We have also the podcast and the blogs, because all the knowledge in this field could be really helpful to expand our knowledge and our comprehension. And then, of course, this is a corporate crime litigation toolbox, the third part of our platform, where you find the global toolbox, the 17 national reports that are already published online. We published them between February and March. And shortly also, we will have their translation, their executive summaries, as soon as well as other tables, graphs on this topic. So I just invite you to look this, and as we unveil this toolbox today, I invite you also to join us on this remarkable journey. With these resources at our disposal, we strive towards not only to confront the urgent climate challenges of today, but also to shape a just and sustainable world for generations to come. Let us now turn to the discussion, which is going to be enriched by the knowledge that we are part of a larger transformative movement. Nigel, please.
Thank you, Ivano. I should just preface what I'm about to say, but by my remarks have been heavily controlled and drafted by Ivano. So if there are any jokes, they're his fault. Before we dive into the conference, it's my privilege to introduce our keynote speaker, Professor David Boyd, who we both met and listened to with great admiration at COP28. As the UN Special Rapporteur on Human Rights and the Environment and an Associate Professor at the School of Public Policy and Global Affairs, as well as the Institute for Resources, Environment and Sustainability at the University of British Columbia, Professor Boyd brings unparalleled expertise to our gathering. His opening remarks will not only frame our discussions, but also underscore the importance of this project for stakeholders and the legal community worldwide. Professor Boyd.
Dear friends and colleagues, hello from Canada. Let me start by expressing my heartfelt gratitude to the British Institute of International and Comparative Law for its very useful Global Toolbox on Corporate Climate Litigation. Having reviewed the toolbox in depth, I can attest to the fact that it contains a wealth of information and insights that will be very useful to litigators, judges, and others going forward. And the timing could not be better. As everyone attending this launch is surely aware, we are in the midst of an unprecedented climate crisis that is already wreaking havoc on the lives of billions of people. In my work with the United Nations, I've met Fijian villagers forced to relocate because of rising sea levels, Sami people in Norway whose reindeer, the living heart of their culture and their economy, have been starving to death because of climate change. I've met farmers in the global south who told me that the heat is becoming unbearable for them to work in the field during the day. In Kenya, I met pastoralists whose cattle, their life savings, died because of unprecedented droughts. So people are turning to litigation in a desperate search for accountability and more urgent, ambitious climate action. Too many governments and too many businesses have ignored climate commitments, broken promises, and gotten away with it because of the lack of strong enforcement and accountability mechanisms in the Framework Convention on Climate Change and the Paris Agreement. So in recent years, we've witnessed a surge in climate change litigation with some truly historic victories. The Urgenda decision of the Supreme Court of Netherlands, the Future Generations case in Colombia, the Torres Strait Islanders victory at the Human Rights Committee in a case against Australia, and many, many others. Most of the cases and most of the analysis have focused on state obligations, but businesses also have responsibilities, and this part of the climate change litigation universe is less studied and less advanced. For these reasons, the Global Toolbox on Corporate Climate Litigation is well conceived and well timed. There are two other types of corporate climate litigation that I must mention. One is the rapidly rising use of claims by foreign investors using investor-state dispute settlement agreements found in thousands of international trade and investment treaties to challenge climate action. Italy was forced to pay hundreds of millions of euros because it banned offshore oil and gas exploration. Slovenia is being sued for more than 500 million euros because it banned fracking or hydraulic fracturing for natural gas. Germany and the Netherlands are paying billions of euros because they gradually are phasing out coal-fired electricity. And the regulatory chill from the mere threat of these cases has prevented states, including Denmark, France, and New Zealand, from going ahead with strong regulations intended to address the climate crisis. The second type of corporate climate litigation involves challenges to government climate regulation in the domestic legal system. And here we are seeing a very positive but unexpected use of the right to a healthy environment as a shield against corporate lawsuits. Courts are accepting that governments are fulfilling their human rights obligations by enacting stronger climate and environmental laws and policies. Friends and colleagues, you have a star-studded lineup of speakers today, so I'll stop now and merely reiterate my congratulations on the launch of the excellent Global Toolbox. Thank you very much.
Thank you very much to Professor Boyd. His insights set a profound context for our exploration today. As we venture into the critical discussion ahead, we should carry with us his guidance, his vision shared during his opening remarks. So we believe that today's conference is a testament to the power of legal scholarship in addressing the pressing challenges of climate change. We are privileged to introduce a lineup of luminaries whose contribution to their respective fields have not just been influential, but have also set the course for future action and understanding. And as you probably know, we ask each of them to provide their comments on some of the toolbox sections, including different causes of action, procedural and evidentiary issues, and of course, the remedies available in corporate climate litigation. So we are going to begin our in-depth exploration with the first section of the toolbox, which is related to climate change law and environmental statutory provisions. I'm really delighted to introduce a member of our core group, Professor Jacqueline Peel, a leading authority from Melbourne Law School. As the director of Melbourne Climate Futures, her work has been seminal in shaping global environmental and climate change law discourse. Her presentation promised to be a cornerstone of today's discussion, and we asked Jackie Peel to highlight 3 aspects related to this section. Some of the key cases involving companies, climate change, and environment, the main hurdles and challenges faced by the litigants in corporate climate litigation, and of course, the prospects for future litigation in this area.
So we've seen that climate change and environmental laws have been used strategically in corporate climate litigation. And in terms of those sorts of laws, they're coming from different places. Some are international laws or principles, some are regional laws, and there's also a lot of domestic laws that are being used in these ways, that whether that's specific climate change laws like a Climate Change Act or environmental laws that are being used for the purposes of climate cases. A common type of case that we're seeing is one that's using an environmental impact assessment pathway and essentially mounting a challenge to the adequacy of the environmental impact assessment that's being conducted by a company in relation to a particular project. In my own jurisdiction of Australia, we've seen a large number of these cases, particularly around coal mines or coal-fired power projects, where the allegation is that the company hasn't adequately assessed climate change impacts as part of doing that environmental impact assessment. Another example that's discussed in the toolbox is the French case of Friends of Environment versus the prefect of Bouches-du-Rhône and Total Energy. This is an example where the administrative tribunal of Marseille in that case partially invalidated Total's permit for a biorefinery factory, essentially because of the failure to adequately assess the biorefinery's impacts for climate change. A number of these cases also invoke the precautionary principle alongside an environmental impact assessment pathway. And an example here is the Chinese case of China Biodiversity Conservation and Green Development Foundation versus Yalong River Basin Hydropower, where the court used the precautionary principle essentially to put a thumb on the scale in favour of erring on the side of caution when looking at the extent of impacts on the environment. There's also been recent legal developments that really showcase the judicial commitment to enforcing not only local environmental regulations, but also aligning them with global environmental standards and commitments. And a good example here is the Indian case of Hindustan Zinc, where the court upheld a 2012 order mandating companies purchase a certain amount of renewable energy power, as a minimum amount of power from renewable energy sources. And in the judgment, they pointed, amongst other things, to renewable energy commitments in things like the country's national action plan on climate change, and that the renewable energy purchase obligation was deemed to be consistent with India's international climate obligations, including those under the Kyoto Protocol. Some of the main hurdles that are being encountered in corporate climate litigation in this area where we're using climate and environmental laws are really not that dissimilar to those that we face more generally in the broader field of climate change litigation. So this is like questions over whether it's really the role of the courts versus the role of governments to be intervening on these climate issues, questions around establishing standing, and the complexities of trying to establish a causal link between a particular activity or a particular corporation and the broader global problem that is climate change. One instance of this that we saw early on in the US, some of the early cases there challenging corporations, whether that was auto manufacturers or oil companies, failing at the very first stage around questions of political doctrine, essentially a barrier to the courts intervening where the question was seen to be one more for policymakers than for courts to decide. There's also more recent iterations of these types of claims in the US that face a significant causation challenge. Just getting before the courts can sometimes also be a hurdle in of itself if there are restrictive standing rules that are applied. This was the fate of the case, the 1997 case of Ontoro Douglas versus Shell in Nigeria, where again the plaintiffs were trying to address the issue of gas flaring, but the court applied standing rules very restrictively such that they weren't actually able to argue the merits of that claim. More generally, there can be a challenge in applying statutory frameworks like the UK's Climate Change Act in corporate litigation, and that's simply because those sorts of pieces of legislation are set up to focus on government accountability for policy and decision making, rather than seeking to provide a specific avenue for corporate accountability. Another barrier that we're seeing emerge is significant discretion granted to decision makers under environmental impact assessment and other environmental laws, which sometimes prevents rigorous enforcement of climate change related obligations on corporate actors. And again, we've seen this in a variety of jurisdictions. There are cases in the Toolbox, for example, from Japan and Nigeria that illustrate this issue. In terms of the prospects for future litigation in this area, there are many new laws and legal innovations emerging that could provide an avenue for future claims. There's a lot of excitement, for example, about the EU's proposed corporate sustainability due diligence directive, which could provide a pathway for new claims, or the revised OECD guidelines that were reissued in 2023. These both evidence a greater approach of corporate accountability for the impact that companies' activities have on the environment, on climate, also on human rights. The case law is also generally imposing greater government accountability for not just setting targets, but how they're going to meet those targets, which we often call transition planning. And as some of these cases are being brought, for example, under the Climate Change Act in the UK, there might be potential to transpose the reasoning from those cases to a corporate context to try and hold companies more to account for, for example, how they're going to achieve their net zero targets. Finally, I think there's opportunities to leverage different combinations of laws in this area to enhance corporate accountability. So we're seeing in some jurisdictions like the Philippines, which does have a Climate Change Act, that being used in conjunction with laws around disaster risk reduction to help provide a firmer legal basis for claims. Similarly in Kenya, again, where there's a Climate Change Act, this is being combined with environmental management laws to provide a stronger legal basis for these claims.
Thank you, Professor Peel. We now shift our focus to the critical intersection of human rights law and environmental challenges. And it's my pleasure to introduce another highly respected member of our core group, Professor Annalisa Savaresi, whose extensive work at the University of Stirling and the University of Eastern Finland has been pioneering.
Pleasure to be here with you today, albeit only on video, to present the findings of a global toolbox on corporate climate litigation that relates specifically on human rights as a cause for action. Now, as many of you probably know already, there is extensive practice concerning the use of human rights law in climate litigation, and this practice is increasingly manifest also vis-a-vis corporate actors. Now, there are specific limitations concerning the use of human rights law against corporate actors. And these may be summarized as follows. First, there is limited legislation in this subject area. What do I mean by that? By and large, human rights law at the international or the national level targets states. So the obligations in human rights law are obligations of states. And therefore, this legislation does not clearly outline specific human rights obligations for corporate actors. The second challenge is that there is limited practice. In other words, there have been relatively few judicial precedents where courts have relied on human rights law in litigation that concerns corporate actors. This report reviews the practice that does exist and does consider what strategies may be used going forward. In this connection, the report starts by looking at the obvious suspect, which is, again, Milieu Defensi, a case that I'm sure you have already discussed in other contexts because it's a milestone also for the use of human rights law. What the court did in Milieu Defensi, the famous case that was brought by NGO Milieu Defensi against Royal Dutch Shell in the Netherlands, was to rely, amongst others, on human rights law in order to delineate the contours of corporate obligations under tort law in the Netherlands. And this is a very significant precedent that is emblematic of extant litigation strategies that include references to international hard and soft human rights law instruments to corroborate arguments that are principally made on the basis of other sources of law, like tort law. Going forward, There is a building body of human rights due diligence law, however, that is going to increasingly, hopefully, fill in the gap in legislation that we have mentioned. So this new legislation is creating processes for which companies themselves manage their potential and actual adverse human rights impacts. And in this regard, one of the most significant developments is the recently adopted Directive on Corporate Sustainability Due Diligence of the European Union, but similar legislation is under consideration elsewhere. Now, the report outlines which are the essential components that must be considered in order to apply this legislation to climate action and impacts. So, to conclude, it's clear that there is a path forward for continued use of established litigation strategies and liability defenses, but there is also a bright future lying ahead with the adoption of due diligence legislation. So it's time for us all to think about how to use these new tools, and I leave you to discuss how this may be done. Thank you very much for having me today.
Thank you very much to Professor Annalisa Savaresi. Next, this has been really helpful for what we are going to discuss in the next session. So now we are examining the pressing issue of negligent failure to mitigate or adapt to climate change. And to offer his expertise, we have on video our Dutch rapporteur, Professor Albert de Jong, Professor of Private Law at the Utrecht University Center for Accountability and Liability Law, and the Molengraaf Institute for Private Law. His analysis promises to be both thought-provoking and enlightening.
Good morning. It's a great pleasure and honor to be part of this important and timely project. The story of tort law in the context of mitigation and adaptation is one full of tensions. On the one hand, in many systems, it's extremely difficult to meet the elements for establishing liability, and hence the role of tort law appears to be limited. On the other hand, there are strong examples, such as the Dutch Shell ruling, where the court ordered Shell to reduce its Scope 1, 2 and 3 emissions, where tort law is shaped and further developed in adjudicating climate change risks. Here, tort law shows its potential for achieving legal protection and to hold corporations accountable. Thus, for the claimants, using tort law is a high-risk, high-reward approach. Its impact can be considerable. Think of generated media attention, the inspiration of successful cases for new cases, and other incentives for corporations that influence their climate change policies. At the same time, climate unfavorable rulings might set the standard for a considerable period and could sideline tort law. The story of tort law in climate change is also a story largely yet to be written. The main players are known, but how the plot will turn has to be seen, probably already in the near future. For example, on appeal in the Shell case, the hearings are mid-April, and in the Smith versus Fonterra case in New Zealand, but also in cases against financial institutions, such as the recently announced mitigation case of Milieudefensie, Friends of the Earth, against a Dutch bank, ING. For the future, the role of tort law will be mainly determined by how courts address fundamental challenges, such as scientific uncertainties and ambiguities, the complexity of the causes and effects of climate change, the societal consequences that tort liability could have, also for other parties than the litigants, and the effectiveness of tort law with respect to preventing climate harm and with respect to compensating it. Thus, the question to be answered is, do courts take the view that tort law can't handle these kind of challenges, as some courts did in Germany in cases against car manufacturers? Or do they adapt the law, as is also often done in the past, and find new ways in making tort law fit for a script where the issue of corporate accountability is urgent and hot? In that latter scenario, tort law could be seen as an autonomous area of law, which operation is less dependent on the behavior of other actors than the litigants, and where negative side effects of court rulings are not directly a reason for denying corporate responsibility. The Toolbox and the national reports offer valuable insights in the strategies that can be followed when tackling these challenges on their legal merits. That is, however, not to say that tort law-based litigation will be a walk in the park. But I think that there are developments that justify the expectation that the link between tort law and climate change will become more clearer and compelling. To a great extent, this is because climate change adversely affects interests that are traditionally protected by tort law and even belong to the core of it, such as health, environmental, property and financial interests. Consequently, issues of climate liability are seemingly easier, note, not easy, to capture in tort law doctrines and narratives. And also, courts might see that tort law can, and maybe even should, be enriched with notions of responsibility that are enshrined in other related areas of the law, such as human rights law. In some jurisdictions, such as the EU, we see legislative developments that recognize corporate responsibility and accountability for climate change, and these developments are directly relevant for the operation of tort law. The coming years will have to show what the journey of tort law will be. And I'm grateful to be part of that journey through this great project, and I'm looking forward to working further on it.
Thank you, Professor de Jong. Our discussion continues as we move into the realms of company and financial laws with Dr. Sophia Schwemmer, postdoctoral researcher at the Institute for Foreign and International Private and Business Law, University of Heidelberg. Her research brings valuable perspectives on corporate responsibility.
Yeah, good morning. Our comparative analysis revealed three main approaches that use company law or financial and securities legislation as a tool of corporate climate litigation. The first approach is based on provisions that require companies to disclose information, either information related to the financial risks associated with climate change or about their greenhouse gas emissions and the steps taken towards climate neutrality, such as the duties under the CSRD and the CSDDD in Europe. These provisions aim primarily to ensure transparency and accountability and to enable investors and stakeholders to make informed decisions. In the case of undisclosed or incorrect information, many securities laws provide for liability for damages caused to investors in the securities market. And this can then be the basis for compensation claims of private investors, especially in greenwashing cases, which have a relevant effect on the stock prices. Even greater pressure could be exerted by a personal liability of directors due to inadequate measures addressing climate-related risks. In basically all jurisdictions, directors of a company are under a duty to act in the best interests of the company. With regard to climate change, this means that directors need to adequately address and mitigate climate-related risks and may be held liable for making decisions that harm the company's long-term sustainability. However, many, if not most, jurisdictions provide for purely internal directors' liability, which can only be enforced by the company acting through other directors or a supervisory board, and which is not open to climate activists. This means that corporate climate litigation requires provisions stipulating an external director's liability towards third party. And this is only known in some jurisdictions and usually under special circumstances. The third avenue for climate action using tools of company law is what we call shareholder activism. shareholders increasingly use their ownership stake in a company to advocate for specific changes in corporate behavior. And to do so, they try to turn the shareholders meeting into a forum for climate-related issues by filing resolutions, by filing agenda addition requests, or by demanding a say on climate. Of course, in some jurisdiction, shareholder action goes well beyond that and includes legal proceedings in courts to hold the company or its directors liable, but that usually uses the other tools I just mentioned. To summarize, company laws and especially financial insecurities legislation can, in principle, serve as a basis for corporate climate litigation. But the governance structures and requirements for specific claims differ greatly in the individual jurisdictions we examined. And here, I think the national reports can serve as a great basis to go further into the details. Thank you very much for your attention.
So, thank you very much, Dr. Schwemmer. We are thrilled now to have our two French rapporteurs with us today in person. And we will start by introducing Professor Pauline Abadie, who works in the law department of Paris-Saclay University. He is a member of the Institute of Ethical Heritage Law. Pauline will give her views on consumer protection law section of the Toolbox. Dear Pauline, the floor is yours.
Can you hear me? Yes. Thank you very much. So legal actions brought against misleading environmental claims have multiplied in the past few years. 1 week ago, a Dutch court ruled that Air France KLM misled consumers with respect to its Fly Responsibly communication campaign. So I'd like to address a very basic question, and then I'll briefly discuss the main hurdles that plaintiffs will face if they want a claim, a greenwashing claim to succeed. And then I'll conclude with some provocative thoughts, all this in 8 minutes maximum. I was maybe allowed a little extra time, I'm not sure. Oh yeah. The very basic question is, why do misleading environmental claims undermine the fight against global warming? In other words, and aside from the immoral component, which is misrepresentation, why is greenwashing a problem? Well, by pretending a product or a process is environmentally sound or is green when it's not, or so little, greenwashing downplays the necessity for consumers to change their behavior. Greenwashing gives consumers the impression that by making minor changes, they can save the planet. So it deprives them of a clear understanding of their consumption modes, and consequently, it delays efficient action. In addition, greenwashing thwarts awareness efforts made by public authorities and NGOs, and it dilutes genuine progress made by truly committed corporate actors. So greenwashing is also a competitor's issue. From a legal standpoint, greenwashing claims face 4 main hurdles. First, with respect to remedy, greenwashing is a delict. So claimants can obtain, claimants can obtain, is not the actual enforcement of the promise, but only an injunction to stop the misleading claim, monetary damages for wrongful behavior, eventually an administrative fine or criminal penalties. But in any case, parties, whether NGOs or consumers or public authorities or prosecutors or competitors, cannot obtain the enforcement of the displayed climate transition plan simply because the corporate entity has never intended to be bound by the pledge. So the contribution to the fight against global warming is only indirect and limited. Second, with respect to standing, environmental NGOs, which are concerned with climate change, may face difficulties overcoming a standing motion to dismiss because their purpose is not about representing consumers. So they may be prevented from using consumer protection law to combat greenwashing. Third, it's not always easy to convince a court that a given environmental claim is a commercial practice. Of course, if it relates to the promotion or the sale of a product or a service offered to a consumer, that's easy. But sometimes the litigious claim is part of a general commitment that relates to the identity of the corporate entity or the value of the corporate entity. So it's not marketing communication, it's not product communication, it's what is called institutional communication. And so here, things are not really settled whether or not consumer protection law, which is geared to product, can work. And plaintiff must also be prepared to combat corporate free speech defense. Corporations are also entitled to free speech. Lastly, greenwashing claims require to mobilize the science, which means to convince judges that, for instance, natural gas, which was coined by the EU taxonomy, a transitional activity, is not a clean energy, or that carbon capture and storage is not a mature technology, or that carbon offset is not a meaningful contribution to reducing a corporation footprint. So all this means to convince a court that a diligent company should not communicate on that ground. Professional guidelines sometimes exist and they can help, but that also questions the normative value of these professional guidelines, which are recommendations. They're soft law instruments, and it's not always sure that judges can use these soft law instruments as an interpretative tool. To conclude with a few provocative thoughts, we know that in Europe, the trend is both towards specific prohibition of certain environmental claims and ads because the practices that are involved are inherently bad for the environment. That's particularly the case of certain vehicle like SUV or certain activity like fossil fuel energy. The trend is also towards regulating specific claims like carbon neutrality by shifting the burden of the proof. Carbon neutrality pledges are prohibited unless the pathway is explicitly explained to the public. But prohibiting, regulating, making mandatory information to the public, all this is good, but is it sufficient? The backbone of consumer protection law must certainly move away from what? From protecting the weak and ignorant consumer to becoming a genuine, sustainable consumption law. So the core here is not protecting the consumer, but making the consumer an actor of the change. And this would require to admit that consumption per se, consumption in itself is a problem and does not always need to be promoted. Thank you.
Thank you, Pauline. Yeah, we now move back to video and the topic of planning and permitting laws, which play a crucial part in the environmental management. We are delighted to hear about that from a great expert from the USA, a member of our core group, Professor Michael Gerard, founder and director of the Sabine Center for Climate Change Law at Columbia Law School.
I'm going to talk about the planning and permitting laws. Almost every country in the world has an environmental impact assessment law. And in many countries, there is also the ability to challenge the conduct of these laws in court. The legal challenges are typically based on procedural flaws, either failure to conduct an environmental impact assessment at all or in a necessary level of detail, a failure to study certain impacts or follow the right procedures, failure to provide public hearings or other opportunities for public participation. In some places, these lawsuits also include substantive claims, such as the alleged inconsistency of the project with the nation's climate policies. But mostly it's procedural, which means that, at least in theory, if a defective procedure is found, it could be possible to go back and redo it and then get the approval that's necessary, although that can often significantly slow down a project and lead to its demise. Challenges to the environmental impact assessment process are by far the most common form of climate litigation in the United States. Our litigation database at the Sabin Center has identified about 1,600 climate lawsuits in the United States. That's about 70% of all the climate lawsuits globally. Of these 1,600 US cases, about 40% were brought under the National Environmental Policy Act or its state equivalents, especially in California, since states are able to have their own laws. These lawsuits typically concern alleged failures to do the right kind of environmental impact assessment, and if there are also challenges to some of the substantive permits or other aspects of the proposed action, those are typically challenged in the same lawsuit. One common issue in some of these cases in the US, and it's also found in some of the cases in other countries, is the question of whether an impact assessment needs to consider the downstream greenhouse gas impacts of a project. For instance, if you're building a natural gas pipeline, do you also have to present the emissions that will result from the power plant or the factory that's going to utilize the natural gas that is using that pipeline? In the US and in many other countries, one common hurdle to success in these cases is the deference that courts tend to give to the expert judgments of administrative agencies. Though in the United States, the Supreme Court is reducing the deference it gives to our administrative agencies. The final thing I wanted to say is that these kinds of lawsuits can be brought against not only environmentally negative projects, but also environmentally positive projects, such as wind and solar facilities. We see a fair number of lawsuits challenging wind and solar projects based on alleged flaws in the environmental impact assessment process. And there's active discussion in the US of whether there should be partial exemptions from the federal and state environmental impact laws to allow renewable energy projects and other clean energy projects to go through without the threat of this kind of litigation. Thank you.
Thank you very much to Professor Gerard. So now we are going to address contract obligation with an environmental climate change lens. We welcome Professor Mathilde Thoreau-Boutonnet, one of the greatest experts in France on the intersection between contract and environmental law. Just go and see her books. Mathilde is the other French national rapporteurs, and she's professor of private law and researcher in environmental law at Aix-Marseille University, where we're going to organize also the European Summit and the National French Conference. And of course, we are particularly honored to have her as our visiting research fellow at BICL. Dear Mathilde, the floor is yours.
Thank you, Ivano. To start, it is important to note that there are not many climate change litigations in which contract law is invoked currently. Observation of the various national reports shows that contract law has been invoked in only 4 countries now, and in a very few cases. Australia, China, India, and France only for these countries. However, a closer look at these cases suggests that the role of the contract could be more important, I think, as a legal basis may become more and more important in the future. I think, for instance, 4 questions can be raised. Firstly, judges could be called to review the validity and performance of climate contracts, a type of contracts. That is to say, contracts whose purpose is to implement national legislation to combat climate change. This is the case, for instance, with contracts concerning the transfer of carbon credits. Secondly, we can expect some litigations concerning the consequences of new climate legislation combating climate change. Question, for instance, could be raised about overtime and the possibility for a contractor to obtain compensation or negotiate a change of the provision of a contract when the legislation it has to implement requires it to make significant costs. Thirdly, what about climate commitments, and more specifically, all these pledges made by companies, for example, instruments that have the goal to achieve carbon neutrality by the end of 2050, for instance. These commitments are not, I think, only a problem of greenwashing, but also a problem of contract law. They're sometimes found in a communication tool or in contracts with investors or suppliers or all the business partners. They are also sometimes supported by certifications from private bodies. And above all, they always raise the question of the veracity of the statements made. We can therefore expect to see an increase in the number of legal actions in which NGOs will use contract law to demand that companies respect the commitments they have made, of course, or pay damages for non-compliance of these commitments. Fourthly and lastly, in the future, some issues could concern also, I think, contractual climate clauses or provisions located in various contracts concluded with suppliers or subcontractors in the value chain. For example, clauses requiring suppliers a behavior to reduce greenhouse gas emissions and ecological friendly behavior. A judge could be called to assess, to appreciate the effects or the application of such clauses to combat climate change. To conclude, it's true that today the contract law argument is not very important in corporate climate change litigation. However, I think that in the future, we could expect a new type of climate change litigation based on contract law. Thank you very much.
Thank you, Mathilde. Exploring arguments, defenses, and court responses, we have the pleasure now to listen to Dr. Omondi Owino, our Kenya rapporteur. Dr. Owino is senior lecturer at the Jomo Kenyatta University of Agriculture and Technology School of Law in Nairobi and head of Environment, Energy and Climate Change Law at Acorn Law Advocates. Dr. Owino will offer a compelling narrative on how plaintiffs' legal arguments successfully navigate and overcome the traditional obstacles encountered in corporate climate litigation. His perspective is invaluable for understanding legal dynamics in environmental law.
Good morning. I want to discuss some of the arguments and defenses in corporate climate change litigation, and I will do so in 3 parts. I will start by looking at some of the most relevant litigation in this area. I will then quickly highlight some of the common hurdles and finish by underscoring global perspectives and prospects for climate change litigation. In terms of some of the most visible and significant cases, the case of Uganda Foundation versus the Kingdom of Netherlands is material. In this case, the Dutch Supreme Court established precedent by observing that corporate emission reductions by positively contribute to climate change mitigation. And that ties up with the defense of diffuse responsibility, which is to the effect that emissions by a corporate entity are so diffuse as to constitute a drop in the ocean, and such a corporate entity need not bother with them. That defense has been rejected. Similarly, in the case of Milieu Defensive versus Royal Dutch Shell, the court rejected the defense of perfect substitution, which presupposes that even if a corporate entity were to stop emitting greenhouse gases, the portion that that corporate entity has foregone will be substituted by another company which will take up those emissions. The court in the Royal Dutch Shell case therefore asserted the duty of corporate entities to protect human rights and to reduce their greenhouse gas emissions. But similarly, in the case of Luya versus RWE in Germany, the responsibility of corporate entities in climate change impacts has been upheld, and in that case, the plaintiff is claiming 0.47% of his costs, which should be covered by RWE, which should be a correlative contribution by RWE in terms of global climate change impacts. What would be some of the hurdles? The first one would be causation. There is a difficulty in creating a causal link between the harm suffered by a litigant and climate change impacts. In order to address that causal link, there are significant developments in attribution science that attempt to establish a nexus between harm suffered and climate change impacts. In many jurisdictions, the right of standing, also known as locus standi, has been a common hurdle. A litigant is required to demonstrate the loss suffered as a basis for them to file a claim. The practice is varied. In Kenya, the Constitution and the Climate Change Act have dispensed with the requirement for locus standi. Another hurdle would be the political question doctrine. And this would simply imply that the matter that a plaintiff invites the court to adjudicate lies within the political sphere and not the judicial sphere, and as such, courts should not involve themselves in such question. And this point came out very clearly in the Ribnik and Lutz cases, as well as the case of AEP versus Connecticut in the United States. Perhaps another hurdle that I could highlight is proximity, where a litigant desires to establish a cause of action in negligence. It will be very difficult for such a litigant to demonstrate, but indeed the harm suffered was proximate and foreseeable, and this challenge has been particularly visible in Australia. In terms of the global perspectives and prospects, I could perhaps highlight developments in India, where the failure to warn arising from the Bhopal gas tragedy resulting in violation of human rights has come to the fore as a basis upon which litigants could possibly found a corporate climate litigation claim. Looking at France, the BNP Paribas cases have been instrumental in providing a potential cause of action under the French Commercial Code, which then requires a plan of vigilance for environmental change. In Italy, violations of Article 2 and 8 of the European Convention on Human Rights, as well as several provisions of the Italian Civil Code, have been basis for bringing cases before court. Therefore, depending on the diverse jurisdictions, it is possible that going forward, there will be a number of innovative bases upon which individuals or plaintiffs can found corporate climate litigation claims. Thank you for your attention.
Thank you very much, Dr. Wino. So we still keep to work on the procedural aspect of the toolbox, and we are going to explore the issue of standing that, as you know, is critical in environmental and climate change litigation. And we are really honored and absolutely delighted to have Professor Madhuri Parikh with us today. Professor Parikh has come from India, and she's the director and dean of the Institute of Law at Nirma University, as well as our India rapporteur. She will share her expertise and highlight the role of legal standing in corporate climate litigation through its past litigation, hurdles, and potential future application. Dear Madhuri, dear Professor Parikh, you have the floor.
Thank you so much. At the outset, I would like to congratulate for this remarkable work. I'll be sharing very briefly my views on the standing based on the work that all the 17 countries have carried out. So, as far as the standing is concerned, the overall comparative analysis of 17 countries present that uh, there is a comprehensive analysis suggests that it changes with the country to country. In each country, sorry. So there are certain countries where the approach is very liberal as far as the judicial approach is concerned or the procedural aspect of the legal part is concerned. So there we will find a little bit liberal approach in interpretation of the rule of standing or locus standi, standing or locus standi. In some of the countries, it's a mixed approach. Based on certain conditions, the cases are allowed. And in some of the countries, we could find a restrictive approach. So if we go to the next slide. Uh, So here I have just analyzed the country-wise analysis has been presented here in the tabular form. So we can see that in the country like Australia, Brazil, Canada, Kenya, India, and Philippines, the judicial approach is little bit liberal in interpreting the terms of interpreting the standing rule, and the constitutional provisions and the legal provisions are supporting that. And most of the time, the court has taken liberty in making an innovative interpretation of the rule of standing. In countries like France, Germany, Netherlands, and UK, interpretation of parties standing depends on specific criteria. And in France, plaintiff must show legitimate interest that is suffered. In Germany, it is required that a potential injury to the rights to be established. In Netherlands and UK, need to establish a sufficient interest or a representativeness for collective action. So collective actions are allowed, but there is a necessity to prove the interest of the representativeness. Uh, if we go to the Norway and Nigeria, an evolving approach is visible. In Norway, organizations can act on matters that fit their objectives. In Italy and Poland and Japan, there is a little bit restrictive approach, but a progressive change is also visible in some of the cases. So, in case of China, we could find a mixed approach. In some cases, there is a relaxed approach as far as the interpretation of standing is concerned. In some of the cases, based on certain conditions, the decision has been taken. In the last table, the examples are available. In US, on certain conditions, the standing rule is relaxed. So this is the overview of the all the countries on interpretation of standing. Now, if we talk about the most promising past litigations and overall analysis, if we make of all the 17 countries, there are many such cases wherein the remarkable judgments have been given. Some of the judgments I have highlighted here, they are the examples where the rule of locus standi has been really relaxed, looking to the conditions. There are two examples I have taken from the country Philippines, wherein in one of the case, the Supreme Court in the case of Oposa versus Spectrum has taken a revolutionary step in relaxing the rules of standing, and the courts granted standing to a unborn child, that is a future generation's right, has been recognized. In the similar way, there is another case, that is a case of resident marine mammals case, where the right was given to represent the biodiversity fauna with a very innovative approach. In the same case, there are two cases I have cited here. One is in rural litigation and entitlement Kendra case, rural litigation and entitlement Kendra versus state of Uttar Pradesh. This is a case where the innovative approach has been followed by the Supreme Court, wherein the simple letter written to the Chief Justice of India was interpreted as a public interest litigation. So total relaxation of the rule of standi, and the matter was entertained, and judgment was given to ban the illegal mining in the Dehradun Valley area. The second remarkable case is of MC Mehta versus Union of India case, which is known as a Ganga case, where the court took initiative by taking a suo motu action. The court came out through readings of the newspaper, and a suo motu action has been initiated. And in three different orders of the court, the matter has been decided very liberally in favor of the environment. So these are some of the promising past litigations here mentioned. There are also certain challenges when we are dealing with the rule of standing in most of the countries. The one and the most important thing is that there is a promising factor also and challenging also when we interpret the remedies available in tort, because it emphasizes that the personal interest should be in focus. So if we focus that in most of the climate litigation cases, there is a major challenge, because it's very difficult to fix the causal link between the harm and the cause of action. So because many times we are the passive victims of certain changes that are taking place, like the cumulative impact of the pollution by the corporates, or the climate change taking because of that. It's very difficult to prove that the direct causal link between the harm caused and the suffering of a person. The second difficulty that we are facing is that the procedural part of the legal system, where it's very difficult to relax the role of locus standi. Most of the time, the vulnerable groups, are not able to present themselves. So there also we can find a difficulty. As far as the collective action is concerned, in there the representative for representing the collective interest, the procedural relaxation is required. That is another challenge we could see in the most of the countries' legal framework. And based on that, if we see the prospective, you can say the future, you can say positive approach. If you look forward to the global, you can say the future approach by most of the courts, we could see that the shift from personal interest to community interest is highly required. And in some of the judgments, the court has really taken initiative. Like the two cases I have mentioned, the mammals case and the another is the Ganga pollution case. The court has relaxed already the rule of locus standi, and the collective good of the people has been focused. So this kind of shift is also required, and I think uh, slowly and gradually it is visible in some of the cases. So this is the overall perspective on the standing. And one more case that I would like to mention, which is not on the slide. One is the Ridhima Pandey case, which was reported in India. It's the first of its kind where the directly the climate change issue has been reported. So this kind of initiatives have started, and I think when we take the approach of the human right, there is a possibility of relaxation of the locus standi, and that is a future prospect where the judiciary can intervene at many points. Thank you.
Thank you, Madhuri. From standing, we move seamlessly to justiciability, another cornerstone of climate litigation, and most of the 17 case study countries explicitly recognize justiciability as an obstacle to corporate climate litigation. This contrast underscores the importance of justiciability in shaping the landscape of corporate climate litigation globally. Today, we have the pleasure of having with us from Japan, Dr. Masako Ichihara, one of the rapporteurs for Japan, a researcher at the local Climate Change Adaptation Center in Kyoto, where the main focus of her work is in climate change litigation and climate change law. Dr. Ichihara's work provides profound insights into the legal mechanisms available to protect our environment. Masako, it is a pleasure to welcome you. The floor is yours.
Thank you very much. According to the definition provided at Cornell University website, justiciability refers to the types of matters that a court can adjudicate. If case is non-justiciable, then the court cannot hear it. Justiciability rulings usually arise either when the court does not have power to hear the case under the Constitution or it is imprudent in exercising judicial power. This toolbox project observed common features across 17 jurisdictions, some of which allows parties to climate litigation successfully to promote climate regulation or change in conduct of cooperation, while others hindered such achievement. Let me start with the former, the case where justiciability does not prevent success of climate litigation. This is seen in Canada, Nigeria, China, and India. The toolbox indicates 4 legal structures as follows, highlighting the government's failure to adhere to its specific legal obligation rather than vague or broad misconduct, invoking specific statutory or constitutional provisions that grant clear, actionable rights. Based on well-defined procedural grounds that clearly outline how courts can proceed with such cases, or emphasizing the judicial roles in delivering environmental or climate justice. It can be said that all of them remain in the domain of general legal interpretation that would not intervene the political or legislative domain. However, as I mentioned afterwards, we need to be aware that the climate crisis has more and more apparently recognized as a human rights issue or issue of justice, both of which are is no doubt in the center of the judicial domain. We all remember the UN resolutions issued in July 2022, which declares the right to clean and safe environment as human rights. Next, let me move on to the latter cases where justifiability hinders success of climate litigation. The project observed the phenomenon in the rest of our countries in various shapes, and specifically, it indicates 6 points. In the some of them belongs in the domain of the legal principle or material issue. There's a separation of powers and political question doctrine and deference to administrative discretion. And the latter belong to the procedural domain, displacement by written rule, ripeness and actual controversy, and enforceability and redressability. Aforementioned analysis finally drew some implications for future challenges, how we can come over with this hurdle, including the 4 successful countries. Regarding the legal rules or material issues related to the trias politica, such as separation of powers or political questions or difference to the administrative domains, the theoretical politica is a very basic structures of countries of constitutionalism with democracy. But so this hurdle seems to remain as a hard struggle as long as we posit or recognize the climate issues as policy matters, not as human rights issues. But as I mentioned, the global trend is the location is shifting from political matters to the human rights issues. And also regarding to the procedural matters as ripeness or addressability. In either point of the ripeness, we have to keep aware that the climate issue is very accelerating. So we have to be hurry to resolve that problem. And also the redressability partly relates to the trias politica because just many judgments distinguish the negative obligation and positive obligation of the governments. So this is for the end of my presentation. Thank you for attention.
Thank you very much, Masako. So we finished the part on procedure, so we go on the topic of sources of evidence, and we turn to Professor Qintian Pao, one of the greatest experts in environmental law from China. Professor Qin is the lawyer, professor of law, and director of the Research Institute of Environmental Law at the School of Law, Wuhan University. Professor Qin, as you will see on the website, is also our rapporteur for China and a member of our core group, and his contribution adds depth to our understanding of evidence in corporate climate litigation.
Is sources of evidence, which explores the compelling evidence plaintiffs have presented to prove causation and examines how courts assess the adequacy of plaintiff's evidence. The assessment is based on causation tests, standards of proof, and rules regarding who bears the burden of proof. The most relevant cases are focusing on the rule, scientific evidence, and expert testimony, which are crucial in determining causation. In the 17 jurisdictions studied, an obvious trend is that scientific report, environmental assessment, and support from experts become a central part in evidence of climate litigation. In the case, motion was a state of Himachal Pradesh in India. The tribunal considered various sources of evidence, including the expert committee report appointed by the High Court Himachal Pradesh, a study by the Indian Institute of Forest Management in Bhopal, and statistical data from the World Meteorological Organization. In Italy, cases such as Greenpeace, Recommend, etc., was ENI used the scientific conferences and RPCC reports to argue that the companies like ENI, aware of the climate impacts of fossil fuel since the 1980s, have contributed to the climate crisis. In the Shenzhen Xiangfeng administrative punishment case in China, reports from the institution are submitted as evidence to evaluation of carbon quotas. Similar practices have happened in Japan, the Netherlands, Norway, Philippines, and the UK, where RPCC reports are cited to reinforce the recognition of climate science in the courts. The most common hurdle lies in the establishing causal relationship between carbon emissions and specific harms. In many countries like China and Norway, establishing a robust causation link between the scientific adverse effects of climate change and the actions of corporations remains a challenge. Often it is hard to establish a direct link. The damage caused by climate change is long-term, latent, and continuous. Such features make the causal chain relatively complex. Moreover, climate change is the result of the actions of multiple actors, and no single emitters can be attributed as the cause of particular harm. As for the future prospect, future climate-related disclosures and enhanced scientific evidence are in demand of further development, which have been recognized in the research result of Canada, China, Philippines, and Norway. Climate-related disclosures are beneficial for the people's right to access environmental information and enriches the scope of information. While enhanced scientific evidence could contribute to the overcome of challenges of proven causation in corporate climate litigation, these two aspects are deemed to be potential areas to make further advancements in future. Thank you.
Thank you, Professor Quinn. We now move to our last two speakers covering remedies. We are joined by Professor Attilio Pisano in person from Italy. Professor Pisano is Professor of Legal Philosophy and Human Rights at the University of Salento and our Italy rapporteur. His analysis will shed light on the legal strategies and obstacles encountering in pursuing pecuniary remedies in corporate climate litigation. Attilio, you have the floor.
Thank you. Thank you so much. The section of the Global Toolbox dedicated to the pecuniary remedies outlines the evolving legal strategies and obstacles encountered in pursuing pecuniary remedies in corporate climate litigation across the 17 case study countries. Pecuniary remedies awarded thus far involve both compensatory damages, as for example in Canada, in China, and Australia, and punitive measures through fines, specifically in the United States and India. Emerging cases reflect a growing trend towards seeking diverse forms of compensation and accountability for climate-related damages. These efforts include claiming climate damages for deforestation as an independent category of damages, as for example in Brazil, demanding funding for climate change adaptation in the United States, and expanding the scope of climate-related damages to cover more harm in France. Moreover, legal development in the United States and Australia have shown initiative to levy financial penalties on directors and officers for failing to fulfill their climate-related fiduciary responsibilities. The cases cited above illustrate a growing momentum towards advocacy for various forms of compensation and accountability concerning climate-related issues. On the other hand, it must be observed that there is an absence of reported cases or success in claiming pecuniary remedies in several jurisdictions. The former is generally attributed to case dismissals due to lack of merit or procedural issues. The latter might indicate a possible shortfall in the legal frameworks, especially in providing financial remedies for climate-related damages and accurately calculating them. Furthermore, the inadequacy of monetary remedies to comprehensively address climate change extensive consequences underscores corporate climate litigation inherent limitations. Additionally, navigating through legal hurdles and challenges, claims for pecuniary remedies in corporate climate litigation encounter various challenges. Several jurisdictions report a lack of cases or a lack of success in securing financial compensation for climate-related damages. In addition to claims being denied based on their merits, such as in Nigeria, claims for damages are preempted by preliminary legal issues. These issues, including jurisdiction, standing, and justiciability, have arisen in several cases in the United States or in Canada. Moreover, this situation may also suggest that existing legal frameworks are insufficient, particularly in terms of providing financial redress for climate impacts and precisely quantifying such damages. Furthermore, the relying solely on monetary remedies is criticized as inadequate for addressing the broad spectrum of anthropogenic contribution to climate change. For instance, with the concept of the Nigerian oil and gas industry, courts have often faced criticism for awarding minimal damages that fail to adequately compensate the climates for their suffering and do not effectively deter polluting corporations. The challenge in determining appropriate compensation or fines lies in accurately quantifying damages while also considering what is reasonable to mitigate adverse repercussions on businesses. Actually, minimal fines risk being viewed by companies as merely a cost of doing businesses. Conversely, excessive fines can negatively affect innocent stakeholders such as employees and shareholders and potentially lead to company bankruptcy. Looking forward, innovative approaches such as calculating compensation based on a company carbon footprint will provide more direct and equitable remedies for climate-related damages. Consequently, the evolution of this legal landscape suggests a continual research for remedies that not only penalize harmful corporate behaviors, but also ensure meaningful restriction and act as a deterrent against climate change. Thank you.
So we arrived to the last speaker. Now we delve into the non-pecuniary remedies with Professor Michael Tu, our Philippine rapporteur. Professor Tu is assistant professor at the University of the Philippines College of Law and is a member of the Philippine Working Group on Business and Human Rights. His perspective brings us full circle, emphasizing the breadth of legal approaches to environmental issues and climate change ones, of course, and providing a comprehensive and comparative overview of the use of non-pecuniary remedies in climate change and environmental litigation across the 17 countries. So, yeah, last one.
Good morning. Apart from pecuniary remedies, we also looked at non-pecuniary remedies across the jurisdictions that we've studied in this global toolbox. And we see that there are a variety of these remedies to account for the multifaceted corporate climate change litigation that we have existing in these jurisdictions, as well as the impact of climate change itself would account for a lot of factors. And we see that the most common would be injunctions, where courts would order a corporation or an entity to do something or to refrain from doing something in countries like Canada, Brazil. We also have in the US, as well as in Poland, injunctions exist. And of course, they also, in some form or in some way, are present in the other jurisdictions that we've studied. Declaratory relief will also be present in that there are always remedies, whether they are called declaratory relief or some other name, that will declare the rights and the duties of the parties to a particular action. Ohenda, for example, established duties relating to climate change mitigation by anchoring that in their civil code's duty of care. The Jonah Gembre case was about the responsibilities or duties of oil and gas companies in their gas flaring activities in relation to the constitutional rights to life and to health and dignity. Preventive measures are also common across these jurisdictions, and they mostly target behaviors of corporation. For example, in the Notre Dame case in France, we have a court ordering a corporation or entities to prepare their vigilance plans on the basis of their duty of vigilance. And so there's a way of preparing for potential harms that might happen or might occur out of their activities. Restorative measures like repair in the German case of the Yuya, where there was sharing of costs in order to repair or restore a particular area because of the consequences of the activities of the energy corporation there is also an example of that. We also have corrective actions and public civil actions. In corrective actions, we see that in the Mehta case in India, which established the absolute liability rule, and the Ibama case, for example, that was really anchored on the protection of collective rights. And so public interest litigation is also rich in these jurisdictions. In the Philippines, we have special writs called the writ of continuum mandamus. In the case of the cleanup of Manila Bay, this was a continuing order of the court to clean the body of water and to report at regular intervals. There's also the writ of kalikasan, which was issued by two indigenous cultural communities against mining activities of a corporation. Citizen suits, which also grant for liberal standing, was explored, and certain reliefs were granted in the resident marine mammals case, which is a landmark case in the Philippines that declared a service contract for exploration of oil as unconstitutional. Specific performance orders, in particular in the UK, also combine features of these preventive, restorative, and corrective measures that we've already discussed. And so these are the remedies, the non-pecuniary remedies that target so many of the aspects of the impacts of climate change. And in many cases, the courts tailor these remedies to address or to target the specific problem that was part of the case before them. So given all these non-pecuniary remedies, do we still have challenges? Yes, we still have challenges, and mostly they stem from the peculiarities of the legal tradition that we are talking about. It has something to do with the hesitation of the courts, for example, to recognize particular rights or emerging rights because of the way in which rights are identified in their jurisdictions, and some are more open and some less so. We also have the major consideration of the economy and economic impact. In the Alar Iru case, for example, in Nigeria, while the plaintiffs there were granted damages, the court stopped short of issuing injunctions because that would be tantamount to making the corporation stop its operations in the area, and that would cause such an economic disruption. And therefore, the economic consideration outweighed, so to speak, the violations and the reliefs that would have addressed the particular problem that they were encountering here. Together with the legal tradition, of course, you have judicial approaches that might lean towards more restraint And part of that really is also factors like how to satisfy causation issues and the high threshold of satisfying as well concrete danger. And we see that in Japan in the case of the Kobe coal-fired power plant, where concrete danger was not established according to the court. And in the Philippines, you have, and I would suppose in across jurisdictions, you always have the problem of effective implementation and enforcement. And so while they may be granted by courts, we have a question of how to enforce these orders, given the nature of corporate entities and their operations, as well as just this enormity of the problem of climate change and addressing or targeting the particular impact. Also because it is difficult to see how much effect the implementation of the order would be given the nature of the phenomenon that we are talking about. But the future is not bleak. Non-pecuniary remedies allow us to think about further steps and how to fashion these remedies so that we are able to effectively address the problem through corporate climate change litigation. And these remedies tell us that more and more we see the multifaceted nature of the problem, and so that it's also multi-directed in the sense that the non-pecuniary remedies do not only target a particular problem, but actually many parts of the problem, and therefore they work together to make the situation better. They are also mostly preventive and restorative. In the case of Xunshan County in China, the carbon sinks approach and its policy resulting out of that case was helpful in imagining what could be a restorative approach. And so the takeaway here for all these non-pecuniary remedies is that they're all anchored on rights, whether we're talking about declaratory relief or clear legal rights in the case of injunctions. These are all rights-based remedies, particularly in public interest litigation, where you have collective rights emphasized in some of those cases. And they tell us that courts often engage in balancing of certain interests, environmental protection and addressing climate change on the one hand, and of course, economic considerations and particular legal traditions on the other, and what that might mean for their norm formation and the availability of remedies and the ease of use of these remedies in these jurisdictions. And often, as we've seen throughout this morning's presentations, a lot of these jurisdictions inform each other in how this balancing often happens. All right, so thank you very much for listening.
Thank you, Michael. I said it couldn't be done. We have managed to go through 17 contributions, and we still have 16 minutes left before we reach our deadline. That gives me an opportunity, first of all, just to thank the speakers, and Ivano, I'm sure will echo that. As we transition, to use a climate change word, into our discussion, could we think about the detailed contributions we've had, any questions that you have, not just to us, of course, but to those who are in the room and can answer those who've been speaking in the room. The videos will be put on the BICL website and also the slides, and there's certainly a revisit is worth having. There's one question from those who have been watching rather than joining us, and that is by Mohammed from Pakistan. He is a judge in Pakistan, and he asks an important question which really reflects where we're going in BICL. He says that in his country there's a lot of these cases coming up, and all of the obstacles and problems that we've been looking at arise. And he asks whether we have considered the Pakistan jurisprudence. And the answer, unless Ivana corrects me, is we have not yet, because we have only been working with 17 countries. We hope to expand that to the world with no limit subject to funding, so maybe 18 countries. But if anybody has a question, please fire away, and I'll keep an eye on questions from those who are watching.
I would just add on that in fact, during the next phase that we are starting this afternoon, which is the national conferences and the regional summit, we are going during the 5 regional summit to start including in our work the new rapporteurs from some countries that we consider important for the next phase of our project. So yeah, Pakistan definitely might be one of those, but it's something that we are going to decide also with the other rapporteurs and with the corporate group members. But yeah, this is the idea. During the regional summit, we are going to include and to expand to new countries. So from 17, the world, hopefully, at a certain point.
So are there any questions from the floor?
Garden Court Chambers. Thank you. It's a question about standing, and it may be that I've forgotten some case law that I should have remembered, but I was involved in a case recently in the Privy Council where we argued on behalf of nature in an environmental impact case, the Mussington case. And the Privy Council effectively said, look, anybody who has an interest in the fish, a fisherman, for example, can bring a case on behalf of the fish if they're being affected adversely by a development. Same for bird watchers, same for archaeologists. Anybody interested in history if an archaeological site is being damaged by a development. And it just occurred to me that in terms of standing, and I heard the professor talking about it, whether or not there are many cases yet about nature and people acting on behalf of nature, bringing tort claims against corporations. And I haven't read your tort part of the global toolbox, but it seems to me that if those cases haven't been brought yet, perhaps we should be bringing them on behalf of nature, and particularly those elements of nature that are being, clearly adversely affected by climate change, by fossil fuel companies and the like. So it may be that there are cases out there already, and I've just not been looking at my talk books recently, but if not, perhaps we should be bringing them.
Can anybody provide the answer? Because,
No, we give to, yes, please. Bravo, thank you, Liam.
Okay, fine. So there is one case that I would like to mention from jurisdiction of India. There is one case, Taj trapezium case. It's a very old case, decided long back around 1997 or like that. So the case was regarding there were some factories near the Taj. Taj is a very famous, you can say, heritage place, and the air pollution from that particular group of industries was damaging the monument. So the initiative was taken, matter was brought to the court by the lawyer MC Mehta, and again it's a public interest litigation. And in that, the court took action and gave the order to the all the factories to stop the air pollution and to just change the place of operating. So this is one case, and even in the Ganga pollution case, also the same approach has been followed by the court, where it was a case related to polluting river Ganga. So direction was given to one, first of all, to one municipality, and then the same order was made applicable to all municipalities situated on the bank of river Ganga to take action, not to dispose of waste in the river, and to all the industries to indirect disposal of waste through municipal waste disposal channel to the river Ganga. So these are two cases wherein quite long back the action was taken. And I think one more case I was reading when I was analyzing this section on standing in the case, even the mammals case that was reported from Philippines, that was also like that, where the stewardship principle was applicable and the action was allowed. Thank you.
could I just add to it? There is litigation in the UK bubbling, if that's the wrong word, in relation to sewage in rivers. And that work is based on harm to the environment rather than global climate change. But an inevitable follow-on is the lack of water, the lack of rivers, which will affect not just fishermen, but nature and also living in the world, and drought and caused by climate change might well be a topic. Next question. There's one right at the back.
Good morning. My name is Rodrigo. I work in Howden. First, more than a question, I would like to say thank you to everybody to participate in the toolbox. It is really impressive. I would say being engaged with climate action and specifically litigation, this is a space that it was greatly needed. And navigating through the laws and the litigation, it is a very complex, considering it's a worldwide complex system. Having this toolbox is going to provide so much help, not only to educators, but also to justice. So thank you very much for the effort. The question that I wanted to do is, do you have in your plans to translate the toolbox to another languages?
So we are using as the idea, and we are from BICL, we decided that we use for this phase of the toolbox the lingua franca, which is English. But for example, as you see, as I was showing before during my introductory presentation, we are going to have also translation of the different national reports. So this in a way is because the goal of organizing these national reports is not just to have gatherings of academics, hugging each other, but it's really creating, a sort of movement where we have the academics, the practitioners, the NGOs, but also the companies, all the most important stakeholders joining together, trying to discuss this issue, because corporate climate litigation, we don't want to make sure that there's going to be more corporate climate litigation, but that is more effective in the different countries. So what we are trying to do is to create groups for each country. And then, of course, the comparative aspect of BICL is that we are going to put them in a connection. That's why the English language is working well for us from that point of view. But as I said, we are going to have also executive summary translations. And we are going to have a certain point, probably by the end of this year, an executive summary summing up all the different aspects of the toolbox in terms of numbers. We know very well, as we see from the great work from our colleagues at LSC, that people love to see the numbers of climate litigation. We are going also to do this. And so that will be translated in also the other 5 UN languages. So to try and really thank you very much for your question.
And if I could just add the reality response, translation costs money, and BICL needs funding, and on the way out there is a collection box. But currency in any currency. Next question, James.
Can I extend my congratulations? Sorry.
For those.
Yep. Congratulations to BICL for the toolkit or toolbox. Fantastic endeavor and well done. I have just one sort of general question about the growing action that's being taken to deal with greenwashing and corporate sustainability due diligence and so on, all of which I support. But I have a sort of general question for you in the context of the urgency that's been spoken of in the context of climate change. COP28 recognized that 2030 is going to be a key milestone date, by which time we have to have tripled, at least they have a goal for tripling the capacity of renewables, as well as various other targets. And all of that is going to involve, I think, us having to invest in new technology as well as a lot of proven technology. And I just have a slight concern that directors and companies and private capital, which are going to be essential to the transition, may be discouraged by the potential growing liability and move the capital to safer areas, which isn't necessarily what we want. If I could draw an analogy, maybe, looking at COVID vaccines, we were prepared for the first time actually to push things rather faster and worry slightly less about liability in the interests of getting a solution, how can one develop the legislative and regulatory procedures in a way and if you like, grow litigation, but not find that it actually discourages the kind of actions that we want? Rather complicated questions. I'm sorry, I should. Yeah, I noticed you're immediately given that. Thank you.
So thank you very much for your question, Professor. So I believe that yes, we all very aware of the risk that we are currently facing. We know very well that by 2030 we should be able to do something that at this point we never done. And I mean, it's like 6 years, even less. So what we try to do at Bicol with our little means and with our modest contribution is to just be part of this solution. We realize that, yeah, international agreements and the international framework in general is fundamental, but as we know, the states are a little bit lagging behind, a little bit very. And so climate litigation, as we've seen, is fundamental. If you ask when you ask if this could, in a way, be a deterrent for states or for companies to act better, I don't think so, because I believe that what we are providing here at Bicol is we try to harness the collective intelligence. I like to say that from legal systems that are very different, to try and also harvest their best ideas that they have, to try to put together all these inventory of potential legal avenues, but also take stock of what we have out there in other kind of litigation. And this, in a way, raising our knowledge on the possibility this kind of climate litigation will bring. I don't think that might be, it cannot be something negative, also because there are many companies that at this point wants to do this energy transition. And so knowing that the one that are faking, or as Pauline was saying, are greenwashing themselves, they will be just in front of the responsibility. So we have a little time, we have some responsibility, now it's time to act. And we think at Bicol that climate litigation could be just one sort of push in that direction. The rest is, of course, a matter of states and the corporate governance. So I hope so. Thank you very much.
One last question, and then I'm going to read a question from online, but there was one question handed at the back, yes.
Hi, I'm Hannah from Travis Smith. Thank you so much. It's been really fascinating and thought-provoking. I just had a question. A lot of the speakers mentioned causation as a kind of key obstacle, particularly in relation to tort claims. And I know in a lot of cases, attribution science is discussed, and a lot of people feel we haven't sort of got to the place we need to be able to attribute specific harm. I know in the New Zealand Supreme Court case of Smith and Fonterra, while attribution science was discussed, the court felt that actually what needed to be proved on the causation issue was a significant contribution or a material contribution to climate risk, as opposed to putting a specific figure on it or even having all known contributors to pollution before the court. As far as I understand, that's kind of a deviation, the New Zealand Supreme Court, but it would be a real win, I think, for claimants if other countries were to sort of take that approach. So I guess the question is, do you think that's likely that other countries might sort of follow that path where attribution science isn't ignored, but it's not sort of fixated upon?
Thank you. It's my own view is that's really, you put your finger on the purpose of this toolbox, and that is to have international dialogue. And when we were talking about this in the early days, it was to think about places where climate change litigation was speedier, was efficient, and the hurdles were not so bad. Very quickly, we found that most jurisdictions have some kind of problem that needs to be considered, and considered internationally. So that also means that in some states, some jurisdictions, if the political will is there needs to be legislative changes to enable speedier, more efficient climate change litigation. It should be treated differently from other litigation because of the threats to the planet and us. So an answer is yes, eventually, and keep talking to everybody. Before we close and before I ask Ivano just to say a few words, I emphasize because it's Ivano, just a few words. It's not a question, it is a question, but I thought I'd just read it to you. It's from Brazil, and Brazil will be the host of COP30 in 2 years' time, or next year. And this is from Karina Oliveira, University of Brazil Law Faculty. Congratulations for the very interesting project. I would like to know if you intend to analyze specific themes which could connect different jurisdictions. For instance, the theme of marine and maritime issues related to corporate climate litigation. And the short answer is yes, we would like to, but again, it will need funding because it's the maritime world is itself an expensive part. Could I just then hand over to Ivano to close the event?
Thank you very much. Yes, I see there are some very interesting questions that we're going to reply, that were in the chat. We're going to reply by email. Anyway, just to reply the last one from Corinna Gellen, is about the possibility of transfer these to other topics, again, like biodiversity loss, and if this toolbox serves as starting point for addressing these other planetary boundaries as well. Yes, this is one of our goal is to try and create also to bridge with the others very important topics also because climate change without biodiversity, you know, is not really affecting vice versa. And so, yes, and of course, this is something that we are going to keep you updated because you will see as the toolbox is going to grow that there will be other sections, of course, very interesting. So, thank you very much. I just have some concluding remarks very shortly because I have also to acknowledge also all the great people that work on this project. And first of all, the national rapporteurs for the great jobs we have here. Some of them, thank you very much. A little post to all of them because they've done a great job. So, as you know, you find online the report. They are already all published on the CCL platform. Our co-group members also for their experience, advice, and support during the different phases of the project. I would like to thank personally our incredible researchers and research fellows that are sitting here with us, Crisela Bernardino, Anthony Wenthon, Aditi Shetty, Aline Olshausen. Thanks also to our senior fellows, Jean-Pierre Gauci, Duncan Fairgreen, Irene Pietropali, who really help us a lot with their support review. And of course, thanks to two women without which this wouldn't be possible, our developmental director, Diane Denny, and our project coordinator, who is always behind and she wants not to appear, Jane Cloak. Thank you very much, Jane, for your great work. Thanks also to the constant support and guidance by our great director, Professor Spiros Magnatis. And of course, to our president, Lord Neuburger, for his introduction today and for the support all over the project. And of course, thanks also to the Beacon event team, Liam, Carmer, Bradley, for their great support, for their great work and their patience. I know that it's not easy to do events with us, but especially with me, but you know, thank you everyone and see you during one of these events we are going to organize at Beacon and maybe this afternoon at LSC during the UK conference of the Toolbox. Thanks everyone and goodbye.